Grand Rising. Today is 2025 on the ancient moon calendar, 2026 on the ancient sun calendar, December 17th. All rise and stand and remain standing into perpetuity. This is an Article III ancient court proclamation for the personal, private, and the public. I am Chief Justice Sharon and Peart Johnson. My sovereign living national appellation is shasha and bay. All are in capitis, diminutio, nolo, in red ink, in proprio personna sui juris, in proprio solo, and in proprio heredes. I am, and all Moors are, both aboriginal and indigenous to this land, called Asia, North America, and the adjoining islands, ancient Morocco, and Mexim, the North Gate. We are alive, we speak for ourselves, and present ourselves as the sovereign lords on our land. We the people are the de jure government, the Moorish National Republic federal government, the Moorish American Al-Moroccan consulate, and the universal Article III Moorish American Al-Moroccan consular court. We do possess in our custody all land, all natural resources, all commerce. We, the true living God nation, are war. We are not at war. We are peace. We are the supreme jurisdiction of our own vast estate. We accept, access, and express all eternal, ancient, original sovereign rights at this time into perpetuity, nunc pro tunc. We the people before the United States do hereby state that we are justice. We are universal peace. We provide for the universal peace. We proclaim that the people and our land are safe and secure. We provide for the well-being of all people. And we have secured the freedom first for ourselves and for our posterity and for our prosperity and then for all others. We do state and place the law for America and the nations on the record as stated by Congress for the United States for America, which does include North, South, Central, Mexico, and the adjoining Americana islands. Congress has cancelled all enacted bookkeeping entries that do not correspond with constitutional money. This action is the onset for Moorish sovereign delarium gold receipts and gold and silver. Moorish sovereign delarium gold receipts are ancient stored energy, stored ancient genetic oxyribonucleic acids, stored value, stored intellect, stored thought, stored investment, stored electricity, stored currency, stored creativity, stored labor, stored present antiquity, ancient writings, stored futures, and gold coins. The following is the status of all debt notes. Number 1. Debt notes are not lawful nor legal consideration for the exchange of any tangibles, nor real estate, nor spiritual matters, nor intellectual properties. This is due first to the personam of the estates and tangibles and properties and intellectual assets, and second to the location of said real estate intellectual property. Debt notes were not real, thus the term virtual meaning not in fact, not actual, not real. Therefore, all previous actors, corporations, dependent on said debt notes are shut down permanently. This is permanent, legal, and lawful estoppel and cancellation for the movement of all debt notes. Number 2. Debt notes were made as a fictitious match to bank bookkeeping entries made from nothing but actors' foreign promise to pay. None of the acting promises and enacted promises have been kept. Number 3. No title nor interest nor right is conveyed with debt notes due to the origin of both the title interest and right, as well as the separate inferior, antithetical, foreign, alien, pugnant origin of the debt note. Said debt notes and all of its paper derivatives are void ab initio. Number 4. No law exists that gives U.S. corporations nor their heirs assigns, agents, principals, or any derivatives thereof the right to make entries on their private books that place the people, who are the United States before America, in debt, publicly, nor privately, nor personally. No lawful nor legal right can be built upon fraud. In sections 50, 51, and 52 of American Jurisprudence, second volume at page 584, based on action, it states that no action will recover on a claim based upon or in any matter dependent upon fraudulent, illegal, or immoral transactions or contracts. Number 5. All and any notes that are by law that are given in consideration for contract automatically nullifies and voids the contract. Sailing under the license of a fraudulent piece of paper is not legal. It is not lawful, and it is outlawed. Number 6. The emission of bills of debt upon the books of private corporations for the purpose of private gains is not authorized by the Constitution or the United States, and is unlawful and illegal. Number 7. Duration for all U.S. debt notes is expired according to law. Said U.S. debt notes are not fungible. Number 8. There are no funds set aside for the redemption of the U.S. debt notes. Said U.S. debt notes are not redeemable for gold, nor silver, nor exchangeable, nor substitutable for Moorish sovereign delirium gold receipts. Number 9. 31 United States Code 5115, United States currency notes, states that the amount of United States currency notes outstanding and in circulation may not be more than 300 million, or the amount allowed by law. This proclamation is to further state that the government stands and is the law for the land. We, the Congress, do hereby place this law on the record as intended, and we place it on the record with this spell. Amen, amen, dico vobis, quaecumque algeveritus super terram erunt ligata et in caello, et quaecumque solveritus super terram erunt soluta et in caello. Amen, amen, dico vobis, quaecumque algeveritus super terram erunt ligata et in caello, et quaecumque solveritus super terram erunt soluta et in caello. Amen, amen, dico vobis, quaecumque algeveritus super terram erunt ligata et in caello, et quaecumque solveritus super terram erunt soluta et in caello. Whatsoever we bind on earth is bound in heaven, and whatsoever we set free on earth is set free in heaven. This sovereign government justice stands. This sovereign government justice is the law. Malembe Yezola, peace and love and grand rising.